Please the court. My name is David Kott. I'm a lawyer at McCarter in English, and I'm also chairman of the Legal Affairs Committee of the New Jersey Business and Industry Association, which is the largest trade association of employers in New Jersey with over 20,000 members. We asked this court to adopt Federal Rule of Evidence 702, which is the codification of the United States Supreme Court decision in Daubert. And as we look at this issue, I think it's helpful to go back to basics. You only allow expert testimony if it's helpful to the jury. And the corollary of that is that expert testimony involves highly complex issues, the most difficult for jurors to sort out. And I'm a big believer in the jury system. I think jurors almost always get it right. But I think we have to recognize in the real world that some of these issues are so complicated that they're going to be difficult for jurors to sort out. And they're critically important issues because the experts often opine on the issues that are the core of the case, the outcome determinative issues. Did a physician breach the standard of care? Was a product defective? All of those kinds of issues. Was there a dangerous condition of real property? So the issues that they speak to are not only highly complex, but crucial to the trial. As we look at this court's jurisprudence, I see three different standards for the admissibility of expert testimony. I'm going to run through them in a minute. But before I do that, let me just say, as a matter of jurisprudence, it does not make sense to us that the admissibility of expert testimony turns on the type of case. We ought to have a uniform standard for all civil cases, and I'm here only addressing civil cases. It ought to be a single standard that applies to all of the civil cases. And the three standards that at least I see in this court's jurisprudence are, first, for the non-scientific case, what I would call the net opinion rule. And by non-scientific, I'm talking about, bring the court recently, Townsend versus Pierre. It's an issue where an expert opines, but it's not terribly scientific and not terribly complicated. And I would note that for the vast majority of cases, we're really dealing with the net opinion rule. We're not dealing, and I'm going to talk in a moment about the Frye standard, Landrigan, Kemp, Rubanek. The vast majority of cases are not what I would call the hard science cases. Was the doctor negligent? Did he breach the standard of care? Was the roadway defective in some way? Was my Toyota that I drove here today defectively designed? So the net opinion rule is really a very important rule in terms of its widespread applicability. The net opinion rule dates back many years, and to be admissible under the net opinion, all the expert has to do is base his or her opinion on the facts in the record, and then, in the words used in a number of decisions of this court, give the whys and wherefores. And that testimony will be admissible. The trial judge does not perform any real gatekeeping function as to whether the opinion is reliable. And I'll just give a brief hypothetical, but it's a real-world hypothetical. Typical product liability case involving an industrial machine. Those of you who have sat in trial courts have had these. Question of whether it's inadequately guarded. And the expert bases her opinion on the facts in the record and gives the whys and wherefores why the guarding is inadequate. That testimony is coming in, even though she has no standard that she can cite to support her opinion, no engineering text that she can cite to, no competitor of the defendant who uses that design. She hasn't actually designed it, and she hasn't tested the alternative design. So that opinion, in our view, is simply a personal opinion of the expert, not reliable, and therefore doesn't really assist the jury. The second standard...
Can I interrupt you with
Yes.
a question, Mr. Kott? Wouldn't that be excludable under the net opinion rule?
I'll answer two ways. In my view, it should be. However, I have a fair amount of experience at those cases, a great deal of experience. And either the trial courts are improperly confused about what the net opinion rule is, Justice Patterson, because they're letting it in. And what they're saying is, Mr. Kott, I hear you. I think that's all for credibility. So either they are improperly applying your net opinion rule, or alternatively, they are applying the net opinion rule. And I'll argue as if I were a plaintiff's lawyer, Justice Patterson. Judge, my expert, she relies on the facts in the record, where the plaintiff entered the machine, what the guarding was, what the training was, and all of those things. And I've explained the whys and wherefores. The guard's inadequate because it leaves an opening. It's foreseeable that people will enter the machine in that area. Safety requires that, and you could add the guard without impairing the utility or function of the machine. So maybe I'm saying I'm not sure whether it would be excludable.
It seems to me you're giving an example of a person who may not be qualified to testify as an expert. Forget about the net opinion. You don't even get to that.
Oh, no. This person might be a licensed professional engineer and a graduate of the Rutgers College of Engineering with a mechanical engineering degree.
Wouldn't the court engage in a Swanus hearing at that point to determine whether the expert was qualified before you even get to the net opinion rule?
Well, yes.
Without the criterion Swanus?
Absolutely.
And doesn't Kaplan disallow any personal opinions, Kaplan versus Kott and Wolf?
It does.
So
it does.
where are you then?
I am just saying that in my hypothetical, that opinion often is admitted. And if that's the case, then maybe there is some confusion as to this court's holdings that requires the court to clarify.
Maybe you need to appeal those cases.
I'm sorry, did I interrupt you, Justice?
No.
The second,
Just a comment.
the second evidence rule or standard comes in the more scientific case. And this court has adopted the Fry standard, and I'm going to butcher the name of the plaintiff, to the Hingenay case. But it's a case involving a seatbelt, and whether a seatbelt would have prevented or enhanced injuries and things of that nature. And under Fry, for a scientific case, we do have the question of whether or not the opinion is generally accepted in the field. However, as I read this court's jurisprudence, the trial judge, in determining whether it's admissible, accepts the testimony of the expert as to whether or not it is generally acceptable in the field. That is, the expert self-validates her opinion or his opinion that his opinion is generally accepted in the field. And again, we can come back to situations where that opinion is not scientifically reliable and therefore not helpful to the jury. And then the third type of case, where we have yet a different standard, is what this court has called the novel theory on causation. Usually comes up in toxic torts, pharmaceutical torts, where there is not any agreement at all in the scientific community. The scientific community indeed does not think that a particular agent, be it a medicine or be it a toxic, something used in a factory, causes the disease that the plaintiff has, leukemia or whatever the side effect is. And under Kemp, Landrigan, Rubanek, the court said, no, in that area, you don't need to have even the Fry standard of generally accepted in the field. Instead, the opinion of the expert will be admissible if the expert follows methodology followed by others, and again, it's self-validating. And this is where we really get hung up on our side, because that would mean an expert could opine that something causes a disease when in fact there's no agreement and no support for that in the scientific community. It's not generally accepted in the scientific community. And that would mean that a jury could find causation. And while I have the greatest respect for jurors, there's something wrong in our jurisprudence when 6 jurors in Camden, Trenton, Newark, or any of our other 21 vicinages are able to find that a product or a toxic agent causes a disease when the scientific community doesn't think it causes the disease. But once the trial court allows in that opinion, and it should, because of this court's opinions in Kemp primarily, the jury could reach that decision. So our request of this court is that the court adopt Federal Rule of Evidence 702. That provides reliable standards for the admissibility of opinion testimony. That ensures that jurors only hear testimony that is reliable, and therefore will ensure that jurors get testimony that is helpful to them at deciding the most complex issues that they'll need to decide. Chief Justice, I'm done.
Just one follow-up, Mr. Kott. How would you characterize the distinction between Daubert and Kemp?
Well, I would do it this way. If we look, and I'm going to move a little the distinction between Kemp and Rule 702, Your Honor, because 702 codifies Kemp but adds a little. In Rule 702, it talks about that to be admissible, the expert must have sufficient facts, now that's the net opinion, but also data, and that the expert must have reliable principles. So in Kemp, the expert doesn't need to have any of that. She simply needs to get on the stand and say, I am using a methodology that other experts in my field would use. If we had Rule 702 as we proposed, essentially the federal rule, the trial judge in doing her gatekeeping function would look at the 4 subsections of Rule 702, and she would look at, again, sufficient data as well as facts, and a reliable principles.
So you would not see Kemp as providing for a gatekeeping function on the part of the trial court?
Kemp provides for a gatekeeping, but the gatekeeping is very limited. It is, as I read Kemp, and I know that the court, Your Honor, knows a lot about Kemp from your prior life, but as I read Kemp, we don't look at the reliability of the opinion. We simply look at the methodology. And the reason the court did that was for a policy reason, that the court felt that in what it would call emerging areas of science, that the plaintiffs, and I don't mean this pejoratively, I'm trying to give the policy, the plaintiffs needed an assist. That in the Kemp situation, where 10 years from now it might turn out that the science then said there was a causal relationship, that the plaintiffs needed a lesser standard.
I think that comment may fit Rabanek and Landrigan more closely than Kemp. I mean, Kemp does provide, tell me if you agree or disagree with this, Kemp does provide reliability language that is significantly closer to Daubert than the prior cases. Would you agree with that?
I would, and if I can tack on to my friend Professor Bernstein, if you took, and I did this in preparation for appearing today, if you had Your Honor's law clerks take Buno's comment to Rule 702 and 703 and go through it and yellow highlight each time there is some language in some of your cases that sound a little bit like Daubert, you would find some language in your cases that sound a lot like Daubert. Indeed, in Landrigan, there's some language that, as Professor Bernstein said, that sounds a lot like Daubert. So on the one hand, I could say, I'm not asking you for a big leap here.
So if I can go back to my prior question, what would you say is in, leave the language of the rule aside, what would you say is in Daubert that is not in Kemp, that is missing from Kemp?
Hypothesis, testing of the hypothesis, looking at the literature, an independent look by the trial judge functioning as the gatekeeper, does the literature support it? If we're talking about animal studies, actually delving into the animal studies, and do the animal studies really apply? I'm going to switch over to what Daubert calls the fit side. You could have animal studies, but they might not fit to the case before you.
Is that a function of a distinction between the two rules, or is that a function of the fact that, first, this court's had very few cases come to it. Secondly, Kemp came up in a much simpler scientific scenario than, of course, the huge breadth of federal cases that have dealt into all kinds of areas. I mean, are we really talking about a strong distinction between the two rules, or are we talking about the function of many years of federal jurisprudence that have dealt with many, many types of science that just simply haven't been dealt with by our appellate courts here?
Well, I think the Daubert jurisprudence in the federal courts are not just on science. I mean, there's a lot of Daubert jurisprudence, and that would be one of the things that would be helpful to the adoption of Federal Rule 702, that our trial courts could then have a huge body of law to look to. Because as Your Honor notes, you don't get these cases every day, but in the federal courts they get them quite a bit, and we see way more published opinions of trial judges, United States District Court judges, than we do law division judges. That's simply, I think, in the real world, our law division judges are way overworked. They only have one clerk, unlike the federal judges who have three.
But are you in effect asking us to overturn Kemp?
Yes, yes, Your Honor.
Okay.
I
and I
am.
assume you made this argument to the committee as well.
We did, and it was made by groups. It was made to the committee, but the committee's task, as given by the court, when the court, I don't know whether remand is the right word, when the court remanded to the committee, and the committee's very clear in their report, was asked a very limited role. They were asked two questions. Number one, are there out-of-state plaintiffs pouring into New Jersey to get the advantage of our jurisprudence? Right. And I think the answer is they are. I think even the committee somewhat recognizes that. And the second thing they were asked is, are our lower courts misapplying our experts' jurisprudence? And that's a little hard for me to tell, because our trial courts don't publish their opinions. A lot of cases don't get appealed, and because of the standard of review on expert, meaning a higher standard of review, a lawyer might feel that the adverse expert's opinion was improperly admitted, but it's not going to be reversible error. So even if she takes the case to the appellate division, she may not brief that issue. What I'm going to now say would not survive a Daubert test, but come back to Townsend. This court's opinion 4 weeks ago were three really good appellate division judges, experienced judges. Either didn't understand the jurisprudence that we had on that opinion, or understood it and misapplied it.
Yeah, but that's a different issue. Yeah. So, how many of our opinions would we have to reverse if we adopt your position? Because listening to you, you don't seem to like anything that we have. You don't like the net opinion rule. You don't like Fry. You don't like Kemp. You don't like anything. So I want to know, how many cases are we going to have to pave over if we adopted your position?
I don't know the answer, but it's not all of them, and it's for the reason that I said before, Justice Alvin, and that is, if I were...
I want to have an idea, because you're asking this court to take a very large step.
Well, I'm only
away from, it seems to me, from listening to a lot of cases, not one case, but
without
the whole
an
body.
adversary on the other side.
Okay. Right. Two parts, Justice Alvin, two parts to the answer. Number one, I'm not asking you to overrule all of your cases. Indeed, I could phrase it affirmatively. I'm just asking you, pull this what you said in this case, pull this what you said out of Kemp, put this what you said out of Landrigan, pull this what you said out of Buccalow, the original net opinion case. So in that sense...
And shake it all up and put it in the new rule?
In that sense, what Professor Bernstein said, I agree with. This court's jurisprudence, at times, seems pretty close to what we're asking for. The other thing, second part of the answer is, I'm not asking for anything radical. This has been the rule in the federal courts for a long, long time. This is now the rule in something like 42 of the states. I'm not suggesting that you're bound by any of that, Justice Alden. What I am saying is that the rule that we're asking for, no one can say is some radical rule. It is the rule that is applied throughout the United States.
The distinction between the federal and the state rules does not keep attorneys in the more complex cases from citing the federal cases.
That's
You would
correct.
agree with that?
I would,
If there's
absolutely.
something close, for example, if there's litigation involving the same product in federal and state court, the federal cases, notwithstanding the distinction between the language of the two rules, are constantly cited to our state judges, correct?
Yes, but let me now take you directly to one of our any of our three mass torts, where we have an expert in it. There's an MDL involving, let's pick a product, a medicine. And the MDL is in the federal court in Cook County, Chicago. And the federal MDL judge says, applying Daubert, I'm now going to bar that testimony. What the plaintiffs do is they file against a New Jersey defendant, Johnson & Johnson, Merck, pick any one of our large pharmaceutical companies. That is not removable, even though there's diversity of citizenship, not removable. And they do that so that way they can avoid Daubert. So I can, in a mass tort situation, in Hackensack, New Brunswick, or Atlantic City, I can cite to the end of the earth not only the Daubert jurisprudence, but judge, in the federal court in Chicago, the federal judge Dauberted this very expert. And the judge would be appropriately say to me, you're right, but I'm bound by Kemp.
But you would also you would argue the Kemp language, would you not?
Right.
That the same result should be, your argument would be the same result should occur under the Kemp formulation, notwithstanding the distinction between Daubert and Kemp, if in fact the science is as weak as it is in your hypothetical.
I would, except for, and maybe Your Honor and I have a different view of the holding of Kemp. I think once the expert says, my methodology is what other experts in the field use, under Kemp, it's coming in.
So help us with the $64,000 question. Why shouldn't we take that case and consider in an adversarial context where you come back as an amicus and Professor Bernstein does likewise and assess the differences in the rule?
If you take that case, I promise the court Professor Bernstein and I will be here, will return. The answer to that is a historical one. The business community, I'm going to just generally, I don't speak for the entire business community, but the business community first asked for this in the 2000-2002 cycle. At that point, the Evidence Rule Committee said, well, Daubert's just been decided. We ought to let that percolate for a while. In 2008 and 2009, we asked for it again. The Evidence Rule Committee recommended a slight change to Rule 702 that the court did not act on. So the answer to the question is, I don't know when Professor Bernstein and I will get the chance to come back, because I don't know when a case is going to get up here. But we're now 15 years after we first asked the court to either say, yes, we'll do 702 of the federal rules and we'll do Daubert, or Justice Alvin, no, we like our current jurisprudence, we're not going to overrule 42 reported cases we have.
Other questions, anyone? No, got it. Thank you, Mr. Kott.
Thank you.
May it please the Court, my name is David Bernstein. I've been asked to appear here today on behalf of the New Jersey Civil Justice Institute to testify about the committee's report on the New Jersey Rule of Evidence 702. By way of introduction, I'm the foundation professor at George Mason University Law School. I've been writing and researching about the rules of the admissibility of expert testimony since I was a law student in 1989. And I want to start by thanking the Court for sending this issue to the committee and considering changes to the rules of evidence. And I'm going to be talking about basically three things. First, why the trend has been over the last 25 years since I was in law school towards stricter rules to the admissibility of expert testimony nationwide. a little bit about New Jersey precedent and how that relates to the issue, and finally the trends in other jurisdictions. And I know I have limited time, so I'll try to run through these kind of quickly. New Jersey should update its rule on expert testimony to make it clear that just as in Federal Rule of Evidence 702, trial courts must scrutinize the reasoning process and not just the general methodology of experts who testify in court. The underlying reason why the courts throughout the United States have been getting stricter about these rules is because while in theory the expert is supposed to be the expert of the court, in practice we know that advocates choose who the experts are. And they choose experts not because the experts are necessarily the best expert, the most reliable expert, the most honest expert, but because they agree with the attorney's theory of the case. That's your job as an advocate, to get the best expert for your client. The problem is that this leads to the issue of adversarial bias, with each side's litigation choosing its experts not based on the soundness of their testimony, but their willingness to testify in support of the experts, of the attorney's side, of the client's position. We have a problem where the jury is not getting the best expert testimony necessarily, but is getting a very biased sample. And in many cases, lay jurors simply don't have the tools to ferret out what testimony is reliable and what is not, and therefore the trend has been to ensure that, yes, we have an adversarial process, the jury gets to decide, but only when there's an underlying reliable basis for the expert testimony. Merely ensuring that broad methodology can be reliable is not sufficient. For example, let's say in a criminal case, the prosecutor presents a DNA expert, and the DNA expert says, well, I did a DNA study. But what if you used samples that have been shown to be methodologically wrong in the latest scientific literature? What if you made severe mathematical errors? What if you're using the African American sample and it turns out that the defendant is actually a Native American, and so forth and so on? Merely saying I'm using DNA is not sufficient to render the testimony reliable. The New Jersey Supreme Court was actually well ahead of the curve on this. 7 years before the Supreme Court addressed the methodology versus reasoning process issue in Joyner versus General Electric Company, and a decade before this ruling was incorporated into Federal Rule of Evidence 702, in Landrigan versus Celotex in 1992, the New Jersey Supreme Court stated that to determine the admissibility of the witness's opinion, the court, without substituting its judgment for that of the expert, should examine each step in the expert's reasoning. The court also emphasized the importance of an expert's ability to explain pertinent scientific principles and to apply those principles to the formulation of his or her opinion. This is very similar to the federal standard. However, despite Landrigan, the standard is not applied uniformly. I think that's actually an understatement. In New Jersey, there are many opinions that cite what the current standard is for expert testimony. Only a minority of them cite the Landrigan language, and many of them have much more permissive language. We don't know exactly what the trial courts are doing because most trial court opinions aren't published, but having reviewed New Jersey Supreme Court precedent, Landrigan and others, I think it's fair to say that's not 100% clear when the Landrigan language applies, what exactly the rule should be in each case, and it would behoove the court to try to establish a consistent standard, and preferably a standard that matches the language of Landrigan and Rule 702. Even in other non-Daubert states that were famous for rejecting Daubert in the circles of people who care about the admissibility of expert testimony, like California and my own state of Virginia, the courts have moved towards the sort of standard that I'm talking about, even though they haven't adopted Daubert. So, for example, the California Supreme Court in 2012, citing Joyner versus General Electric, held that trial courts should scrutinize an expert's reasoning process before admitting the expert's testimony. That's the Sargon Enterprises case. Just a few months ago, in January 2015, the Virginia Supreme Court also cited Joyner for the proposition that although experts may extrapolate opinions from existing data, a trial court should not admit expert opinion which, quote, is connected to the existing data only by the ipsy-dixit of the expert. And I think that's the real distinction. Are we relying on the mere ipsy-dixit of the expert, or are we actually scrutinizing how the expert got from point A, the methodology, to point B, the conclusion? Not scrutinizing the conclusion itself, but how you get from A to B. The simplest way for the New Jersey Supreme Court to ensure that this basic reliability rule would be followed would be to adopt Federal Rule of Evidence 702. This rule now represents a settled and well-defined body of case law applicable in all federal and the vast majority of state courts, including a couple of state courts like Wisconsin and Florida, which had once, very recently, been very sort of loosey-goosey about how they treat expert testimony and now have adopted Federal Rule of Evidence 702. Consistency and predictability in the admissibility of expert testimony would only increase if New Jersey were to adopt a standard now used in numerous other jurisdictions, and again, consistent with at least some line of precedent in the New Jersey courts itself. Thank you very much for your attention. I'd be happy to take any questions.
Questions, anyone?